Hi, my name is Sarah Aftab and today I'm here to present our group presentation of legal aspects. The case study we chose is Bank of India versus Gobindram Narendas Sadhwani. I'm going to start with some introduction. Gobindram Narendas Sadhwani was appointed as a guarantor in that situation. They were sued by the bank because of fulfilling some obligations. In the present case study, we are going to discuss the arguments, the legal facts, issues, and the results of the case. The case is explained from one perspective by giving several arguments. These several arguments are given from India. The plaintiff in that situation is Bank of India, who sued the defendant for the non-payment that happened on behalf of Krishan Chand Sadhwani. Now I'm going to discuss some brief facts of the case. Gobindram was a resident in Hong Kong and Krishan Chand was a resident in Japan. Bank of India, whose headquarters in Bombay, issued the loan and given to the defendant parties. The branch office of the Bank of India is in Osaka and Tokyo. Gobindram and his wife are the guarantor of the above amount, taken a guarantee of amount 230 million yen. The loan was provided to a company owned by the brothers named Sadhwanis Limited. The main situation of the company is Krishan Chand owns 60% stake in the company and Govindram owns 40% stake in the company. There are the brothers who are related to the business. In a way, they are dealing in Nigeria and Sri Lanka. Transactions were in real position liable to pay the bill of exchange created by the company. Kishan Chand had drawn the above mentioned bills of exchange in favor of the corporation that is being in Nigeria and Sri Lanka. The present international case involves several issues including disputes, withdrawal, dishonor, and exchange of agreements representing negative intentions. The present case was brought against Gobindram, although at earlier stage bank have released from the liability of the guarantee. As per Gobindram, the law of Japan shall govern because the case according to Japanese law and they are not liable to pay the amount because they were released from the liability. So the Japanese law should follow the case. Now I would like to call Sushil to continue this case. Thank you.
Thank you, sir. Now I'd like to talk in brief in regards to the major issue of the case, which is whether the law of India or the governing law of the Japan is to prevail over the dispute relating to guarantee agreement that has taken place in between Bank of India and Govindram. In this case, Bank of India is the plaintiff and Govindram is the defendant. So the major issue is as follows. Owing to the fact that both plaintiff and defendant are nationals of India, but the place of business is in Japan and the operational area is also Japan. So there is a debate and deep confusion in regards to whether the governing law of Japan or the governing law of India is to prevail in regards to this case. As per the general rule, the governing law of the state, which is closely related to the case, is to prevail. So in order to verify the governing law the following rules can be considered. The number one rule is the place where the parties to the agreement reside or lives. The place as determined by taking into account the implications of the contract terms and conditions. And the third one is the law of the place that was the closest to the relationship with the parties to the case. So among these three conditions, the first two does not clearly present the designations as specific designations and express designations. So the third law, that is the doctrine of having the country closest relationship with parties to the contract or the case, can be used in the absence of specified designations. So owing to the fact that there is absence of any kind of designations expressly made and no implied implications in respect of the designated place have been presented in the terms and conditions of the agreement, the doctrine of significant and closest relationship is appropriate. Japan being the country where the company is established and a negotiation has taken place with the currency used as Japanese yen, the closest connection is found with Japan. On top of that, Kishan Chand also resides in Japan. However, the selected party for arguments in this case is India. So arguments for both Japan and India has been presented in our report. So for detailed insights in argument for Japan and argument for India, I'd like to call my next teammate Arvind to carry on with the video presentation. Thank you.
Thank you, Sushi. Now I will give a brief insights about the argument that supports Japan and also some arguments that's in favor of bank, which is also a selected party under the assignment. And due to following fact, there has been a strong argument in support of Japanese law as the governing law of the case, and the company of the platinum is located in Japan. The negotiation in regards to the transaction is also undertaken in Japan, and the currency that was used under the argument is Japan, and also the Kishan-chan's place of residence is also in Japan. The selected party for the argument being India for the purpose of the assignment. Foreign funds can be considered in support of the Indian law as a governing law. The original dealings in respect of the guarantee contract was initiated in India. The plaintiffs in the present case have got their headquarters in India. Several acts of all the brothers clearly show the willful fraudulent action taken by them in order to extract the money from the Bank of India. Here they took false out and they have the intentions to escape the punishment. Therefore, as per our argument in support of the selected party example, Bank of India, Walker Brothers should reimburse the amount and taken by them or from the Bank of India, considering Indian law as the governing law. So that's it. And now I would like to call my next workmate, Mr. Shahid, to provide more insights in regards to the decision of the tribunal along with the significance of this case at international level. Thanks so
Hello,
much.
my name is Sahil and now it's my turn to discuss my topic, and my topic is decision. The case of Palantir being Bank of India was dismissed because the Japanese law was applicable, and as per the Japanese law, party being Govindaram were not liable to make any point of on behalf of Kishan Chand as per the guarantee contract was cancelled at prior stage. As well as significance of the case in international law, the countries involved in the present case in India and Japan, in order to deal with the cases like the present one, there had to be any treaty signed between the two countries that can govern the relationship between the parties and the choose the state that state the governing was the present situation. The foreign judgment is required in the mentioned case under the common law in order to ensure that in appropriate situations, as well as decision is taken by the court. The foreign court is required to interrupt in the present case because there is a conflict law, and in order to deliver justice and require the judgments as and also and also the judgment of the law is party required of foreign countries and foreign court as well. And when there is conflict as to governing the law of particular country, the interruptions of international court is required in order to determine the governments of particularly decisions, and also their aspects of international that is covered in the mentioned cases. The present case also representable somewhere is the conditions of the court, and that is the effect on that conditions. Thank you.
So, in a nutshell, to conclude, the Bank of India case is basically a very extraordinary case because it just does not involve one particular party or two parties, but in fact, it involves several parties and several laws. And there's a point where actually international law as a whole also is necessary. There's a significant role of international law as well, and the foreign gets involved because such as to take a decision, because in both the parties are somewhere right and valid in their agreement, and although the decision was taken in the favor of the Japanese law, that is in favor of the Gobindrams, but at the same time, these the other part, and it is valid because at the time the liability was taken, Govindrams were not the guarantor of that liability. So it's somewhere it's unfair for the Bank of India, because now there's no one to cover the Bank of India for that liability. But at the same time, it's valid in a way that the precautions and the agreements were not taken by the Bank of India to cover that liability, having Govindrams as the guarantor. So at the time, present actions are being taken by Govindrams not to by the bank to go against and explain that this is actually an intentional act of withdrawal, and it hasn't and this was done intentionally. So at the moment, the debate somewhere is still there, and I think in a conclusion, it's fair enough to have an international law in place, which previously there were no measures, and now the decision is taken in favor of what's right and I think it's a justified decision that's been taken. Thank you.